Legally Speaking with me, Tarun Nangia. Today, we're going to do a short discussion on a judgment passed by Justice Pankaj Mittal and Justice S.V.N. Bhatti. This primarily concerns pre-litigation mediation, or before you file a suit, what mediation has happened. What is it about? Of course, the panelists will explain. The case is titled Sabita Jha versus Aone or A1 Developers Private Limited. So we'll get on to the show without wasting much time. But first, I have to welcome a panelist who joins us for the first time. Senior Advocate Kadambari joins us today. Good to see you.
Hi.
And welcome to Legally Speaking. And looking forward to see you more on the show. And this is your first time, so thank you so much for coming. I have with me Senior Advocate Arvind Nair, who joins us on the show. Ruchi Agnihotri, advocate practicing at the Delhi High Court, Supreme Court, and other forums, joins me. Good to see you. Thank you for joining me. At the outset, I would sort of request Ruchi to give an explainer on this order before we get into the comments that our panelists will make. Ruchi, could you please explain this issue, and then we get into the comments by Senior Advocate Arvind Nair and Senior Advocate Kadambari.
So thank you for having me on the show, Tarun. It's a short and sweet order in that sense, but it's actually, it has wide ramifications if you actually, see what it says, because it is in the light of what it seeks to sort of, deal with. It deals with partial automation judgment of the Supreme Court of 2022, which is a very detailed judgment on the issue of Section 12A of the Commercial Courts Act, which actually says that the concept of a pre-institution of suit mediation is a necessary, mandatory precondition before a suit can be registered as a commercial suit, right? So in that case, parties had gone through a lot of, trial court, high court, etc., and ultimately the Supreme Court said nothing doing. The suit will be rejected under Order 7, Rule 11 of the CPC, and mediation under Section 12A must be first exhausted. It is mandatory, and there is no two ways about it. In that case, there wasn't really, I stand to be corrected, but as far as I can recall, I don't think there was in fact any sort of mediation that had happened there. So the observations of the Supreme Court in the partial automation case should be seen in light of that fact. Now, in this particular case, what has happened is it's a pure, simple commercial dispute between, it's a property development agreement sort of a thing. Parties have contended, we have paid, services have not been rendered, etc., etc. It's a commercial suit, but prior to it being registered as a commercial suit, there was no pre-institution mediation in the, hyper-technical sense of Section 12A of the Commercial Courts Act 2015. However, parties had a mediation process. They had attempted to resolve their matters through a mediation, and they had failed to resolve their matters through that mediation. So in fact, in this particular case, a mediation had happened, which is why the trial court as well as the high court says, sorry, it's okay. Mediation has already happened. We see no impediment in taking this forward as a commercial suit. Despite that, Ms. Sabita Jha decides to go to the Supreme Court in an SLP and says, no, nothing doing. Partial automation is very clear. It's a mandatory provision. Under Section 12A, you have to have a pre-institution mediation, stricto sensu, under Section 12A of the Commercial Courts Act of 2015. So this order, while it is a very simple 2-line order and just simply dismisses the petition and says there's nothing to be explored in this petition, actually can have very wide ramifications for speedy and efficacious disposal of justice. I think it's a trend that the Supreme Court judges are repeatedly showing through small orders, innocuous orders, big judgments, detailed orders, where they are trying to really re-emphasize the point that technical issues, procedural matters are literally handmaidens of justice, and substantial justice must be served at all points. So in this case, it was held, mediation has happened. It may not be under Commercial Courts Act, but it has happened, and therefore let's go ahead, register this as a suit, commercial suit, and let's proceed with the matter.
Thank you for that opening explainer, Ruchi. We go to our first round of comments. Senior Advocate Arvind Nair, over to you for your first comment.
I think, Tarun, as Ruchi said, it's an order with wide ramifications. They relied on the concept of substantial compliance. Those are the words, that's the logic that has been used. And I think in the sense of mediation, substantial compliance, it's going to set a precedent, because we have seen, although the statute for commercial suits does say that you must have pre-suit mediation, but we have seen in India, possibly maybe it's something related to the workload that the courts have, most parties will only take a mediation process seriously when they are directed by the courts to get into mediation. So while pre-suit mediation is a requirement as per the statute, but I'm not sure exactly how effective it is, because commercial suits, IPR suits, similar suits, defendants are often habitual offenders. So to give them that extra leeway and to say that it has to be interpreted very strictly and very technically may not be the right approach. I think that's the route that the Honorable Supreme Court has taken. They have said that, look, substantial compliance has taken place, and that should be good enough. Because when Ruchi was giving an explainer of the case, it was originally registered as an ordinary suit. Then the court sent them to mediation. That mediation failed. Then ultimately it was re-registered as a commercial suit. So the intention that parties must sit opposite each other and save precious judicial time if they can talk to each other and settle the matter had already taken place. So no purpose would have been served by this extreme technical interpretation and having, directing them to go through the whole process again. It's just, not only is it sort of superfluous in the sense that, as I said, a lot of defendants and a lot of parties, even plaintiffs for that matter, are not interested in any kind of settlement. Secondly, it's also waste of precious judicial time. We've got courts where on an average every day judges are hearing 50 to 80, 100 plus cases. So what's the point? We are only going to end up wasting judicial time. I think it's a step in the right direction, and it's going to have ramifications and consequences all in a good way.
Thank you for that comment, Senior Advocate Arvind Nair. In a show recently I did with Justice Arjun Kumar Sikri, Justice Sikri has encouraged mediation a lot in India, but he also joked that most lawyers would consider ADR as an alarming drop in revenue. So, and that is why sometimes to push mediation becomes difficult, because it's labeled as ADR. I'll go to Senior Advocate Kadambari for her opening comment.
Yeah, thank you, Tarun. So I've gone through a very briefly written judgment, although briefly written, but in para 4, they have emphasized substantial compliance. Now, the judgment is an important one, as it has provided a very nuanced, balanced, and an equitable approach to the law earlier settled by the Supreme Court very recently, that too, in 2022, in Patel Automobiles. And in that case, the Honorable Supreme Court had held that the compliance of Section 12A was not only mandatory, but also that the non-compliance of the same could be visited by rejection of the plaint under 711, and this power could be and ought to be exercised by the courts on its own without there being an application. So now in this court, while invoking the doctrine of substantial compliance, which has been quoted, this doctrine has been evolved by the courts as an equitable approach earlier also, but for the first time, this has been applied to Section 12A of the Commercial Courts Act. This provides a relief to various litigants, both qua 12A compliance as well as generally where suits may not present serious dereliction of law, and where substantial compliance in terms of the objective of the statute has been undertaken. So now this interpretation by the Supreme Court applying the doctrine of substantial compliance will, without diluting the previous judgment of the Supreme Court in Patel Automotives, has provided a more equitable and a balanced approach. Now in Patel Automotive, since the court had held that it is a mandatory one and it must be visited by with rejection of the plaint, so this could be applied, if applied uniformly, this could basically be considered as harsh in some cases where inadvertently or otherwise there was a minor non-compliance. And Patel Automotive, it is necessary to understand under what premise and what reasoning was Patel Automotive's judgment given. Because mediation is seen as benefiting not only litigants, as well as the entire justice delivery system. Because mediation as a process is seen to be an amicable resolution of disputes, reduction of burden on courts, and fostering relationships. So from that perspective, Patel Automotive's judgment also, and rightly so, saw mediation as a mandatory process, not just procedural. Now, there is a distinction between that case and this case, as Ruchi had rightly said, because here it was, the suit was filed as an ordinary suit, and thereafter summons was issued. Thereafter, the parties were sent to mediation. And thereafter, it was, by the order of the High Court, it was converted into a case or into a commercial suit. So therefore, in effect, the pre-litigation mediation before the case came to be registered as a commercial suit was already undertaken. There's another facet to it. So the court has again reiterated the oft-repeated principle that technicalities of law should not be permitted to hamper the administration of real justice. So basically, the court has ended up doing the real justice. One more thing in this case was that here not only this factum of pre-litigation mediation was already done, but also it was a case where the entire procedure as prescribed under 12A had already been followed, and it was done by the orders of the High Court. So I think this is a step in the right direction.
Point very well taken. I'll broaden up the topic. Thank you, Kadambari, for your opening comment. That, Ruchi, if you could reflect on, are these days you're seeing a large number of cases being settled at the pre-litigation stage? I would like to point out Lodha versus Lodha case that was settled, and it was a very high-profile matter. I mean, everybody thought it was destined for Supreme Court. But then comes the news that at the mediation stage itself, everything was settled. Can you briefly reflect, that because sometimes litigation takes a long time, people want to mediate and settle. If mediation took shorter time than it usually takes in India, people will still prefer litigation or litigated justice. Just an observation there, and your thing on, do you see mediation now being used effectively these days?
Mediation is a very effective tool, Tarun. There's no doubt about it. However, just like, when you enact a law, but how society perceives that law is very, very important. In the same way, how litigants and lawyers are perceiving the process of mediation and even conciliation is very, very important. The matter that you just talked about is a one-off. It's an outlier. Let's not take this as an indicator of a sea change. It's great. Maybe it flagships attitudinal change. But as of now, I don't know, Kadambari may have the stats. Maybe Arvind has the stats. I really don't have the stats. But I know the sense that litigants or even lawyers have is that mediation is really not a process that is going to come up with a solution. It is more of paper compliance right now for parties. Yes, I think in probably matrimonial matters or personal disputes between, family disputes that are there, I think mediation has seen some success. But in commercial disputes, I don't think that the litigants actually trust a mediator to enforce a settlement. They don't trust the other party. See, the point is they would never have reached a point of a dispute if the other party was doing things as per the contract or that they were honoring the contract. We are already in a breach situation. Some party has breached something, right? Which is why there is a commercial dispute between the parties. So there is already a trust deficit. And the mediator does not have sufficient powers because enforcement is an issue. We are in a situation where even arbitral awards are finding difficulties, and we are trying to streamline that process. So I think we are very, very far away from making mediation stricto sensu again in commercial matters. I again reiterate, in personal matters, yes.
Point very well. Thank you for. I'll go to Senior Advocate Arvind Nair. Mr. Nair, you do a lot of these commercial matters in Delhi High Court and Supreme Court, where there are, this big commercial fights between two parties. Sometimes even the issue recent, I think the medical council case, a lot of other cases. I want to know from you: do you think Indians prefer a litigated settlement, or as Ruchi was saying that they are at a point of no return, that's why they are filing a case? If you could, I mean, it just give me a general observation rather than what you have seen within your experience.
I think there are various reasons. What I have seen, for instance, let's just first talk of Lodha versus Lodha. Yes, everybody did anticipate, it was in the papers. Everybody thought it's going to land up in the Supreme Court, but it's been settled, and hopefully we'll see a lot more settlements. But my view is, of course, I am not privy to the nitty-gritty, but I have a feeling that perhaps the extended family or the immediate family may have had something to do with it. We have often seen in potential litigations between industrial houses, families of promoters, that there is extended family which comes in, which plays a role to, everybody is told that let's not, besmirch the goodwill of the family. So that perhaps may be a reason, that may be one of the factors. I don't think it can be used as a precedent. Of course, there is a lot of focus, there is a lot of encouragement by everybody, by judges, by lawyers, by every stakeholder in the system. There is a lot of push for mediation, but I think we are not there yet. I think it's going to take a while. It has great potential, but I think it's going to take a little while, and it's got various reasons. One is perhaps they feel that how are these settlement awards going to be enforced? That's one part. The other is there is this the faith that they have in the constitutional courts and even the trial courts is something. I think the common citizen, whether it's a corporate or an individual, looks at courts as part of a system, whereas they are still looking at mediators and that vertical as a private body. They probably seem to think it's a private initiative. So this may require some sort of educative push. I'm not sure that they are yet aware that this is a system, this is a alternative dispute resolution mechanism that's being pushed by the judiciary itself. So they perhaps feel that this is a private enterprise, and we probably don't have that kind of faith.
You have a fair point that Indians sort of prefer a litigated settlement. Go to Advocate Kadambari for her, Senior Advocate Kadambari for her comment on this issue.
So, Tarun, I'm handling a lot of commercial disputes, and I feel more and more there is a trend that litigants want out of the protracted litigation. I find, of course, not only in family matters, I'm not doing so many of those, but a large number of commercial disputes. I've seen litigants are getting tired of the lengthy process that the courts do take. And they also see sense in settling and getting the benefit now rather than 10 years, 20 years later. So sometimes what happens is that if a party thinks that they can get away with a benefit, and the rate of interest also goes on, and they will get something out of it which is larger, then it may be a different thing. But sometimes litigation is started as a strategical move to bring both the parties at a stage where they both can see what are the pluses and minuses, what are the strengths and weaknesses of each other's case. And sometimes that also helps a mediator, or sometimes it's a push by the court. It depends on so many factors. What kind of lawyers are guiding you? Maybe if your lawyer is saying that, yes, this is what you can get, but yes, it can come after many, many years, and take it now. I have seen a huge jump in parties in commercial disputes settling the cases and going their way.
Point very well taken. In fact, what I was given to sort of understand by many lawyers is that when the litigant goes to the Delhi High Court and sees a cause list where a judge has to hear 130 cases in a day. He loses all hope that the judge will hear his case because it's not physically possible for him to attend to so many cases. And when the judge has no time to hear his case, then the possibility of a litigated settlement seems very far away. And in that desperation or in that state, he chooses to mediate, is what somebody made me understand. Ruchi wants to come in quickly.
Yeah, just a point. Even the courts who are pushing mediation, and even the things that are falling from the executive wing of our government on pushing mediation as an alternate dispute resolution method. If you read the language of Section 12A, it very clearly says unless urgent interim relief is required. So you see, the problem is the mediator doesn't have that power. And normally when you're in a commercial dispute, you would want an interim order in your favor. So that's the catch.
That's a catch. It's a point very well taken. In fact, we're going to take up the issue once again after the show of the issue of heavy cause list before every judge in Delhi High Court. Why I insist Delhi High Court is because it's a prime commercial jurisdiction. All cases land up here. We recently took up an issue that we need 90 judges in Delhi High Court, given the kind of caseload it has. But I think it's to plan to take up more of that, given that even now we have, I think, hardly 40 judges there. We have a sanction strength of 65. We have 40 judges. We need more judges in Delhi High Court. Maybe we take that up soon. But I would like to thank Senior Advocate Kadambari, who joined us for the first time today on Legally Speaking, Senior Advocate Arvind Nair, Advocate Rishi Agnihotri. Thank you so much for joining us. It was a pleasure discussing this case. Also about the insights that you brought in the second part of the show where we discussed the efficacy of mediation. Appreciate you joining us. Thank you.
Thank you.
Thank you so much.
Thank you.